Hi, thanks for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Jessica Murphy, a Massachusetts construction lien law expert. Today's webinar topic is don't sign a release unless it passes this checklist. So without further ado, I'd like to introduce the fabulous Jessica Murphy.
Oh, thank you so much, Jessie. I appreciate the introduction. Thank you for everybody joining us. And I know this is recorded, so you can come back and look at this again if necessary. Without further ado, my goal is to give you a couple of new pieces of information, hopefully let you leave this webinar with a better understanding of both releases generally and also mechanics lien releases. And certainly if you have any questions that come up, you can feel free to use the chat box, or you can go ahead and reach out to me directly or to Jessie, and those things will get to me. Happy to answer any questions you have. So without further ado, let me get into it. So here's just the guide for how to use the chat box. And please just note that because this is being recorded and is a public webinar, don't use company names or individual names in the questions. You can just use company A or something like that. So just to go over what we'll talk about today is what a release is, why you would want to execute one, what to check before executing a release. So hopefully going to give you a checklist that you can use going forward that you can run down when you have a release come across your desk. The right way to exchange a release for a check, and yes, there is a wrong way. And then we'll talk a little bit about SunRay resources that are available to you. So first of all, what is a release? A release is any agreement by which you're giving up rights in exchange for something else. Oftentimes, what we're really talking about is payment, but sometimes it can be you're releasing your rights in exchange for an agreement not to sue, or you're releasing your rights in exchange for an agreement to change what's going to happen in the future. It is important, and that third bullet really highlights this, it requires consideration from both parties. So one party is giving something up, the other party has to be giving something. If it is just simply an agreement for you to release lien rights, that in and of itself, without any consideration, or if it's just an agreement to release any rights as to any project, without consideration, those are not a valid contract. So that's important. There's got to be something on both sides, whether it's the other side is providing you payment, the other side is providing an agreement to not sue you, or something of the like. There is always something being given up by the other side that makes it an exchange for consideration. So it can be informal or formal when it comes to a general release. So releases as a whole can be informal or formal, doesn't need specific language. It can be called a release, it may be called a waiver, it may be called a settlement agreement, and this is a subparagraph within it. You might find that it's required to be notarized. It does not have to be notarized in Massachusetts. What is interesting though is for a mechanics lien, because mechanics lien releases typically are recorded, those are going to be ones that need to be in writing, and they also need to be notarized because they need that validity when it becomes a recorded document. But in general, a release overall can be in really any format it wants to be, doesn't require specific language, and note that it can be a mutual or one-sided. So if it's mutual, both sides are giving up rights. If it is not, then only one party is giving up rights in exchange for that. There's also language you may find that has a release called a general versus a limited release. And these are for releases in general. A general release is going to be one that releases all rights. A limited release is going to be one that limits the release to just certain matters. So if you have an ongoing relationship with somebody and they have multiple projects with you, and one of the projects is done and you're going to resolve an issue and it includes a release, you would want to execute a limited release that is specific to the particular project you're working on, or maybe just a phase of that project. If you execute a general release, you could be releasing claims as to anything that has happened to date, which is really broad. So just to know that there's some language to be familiar with about a release and what they mean. So why are you going to execute a release? You've either resolved the entire dispute between the parties, you want to put it behind you and move on. You want to know that somebody's not going to be able to come out of the woodwork and bring suit later on. Maybe you've resolved just a portion of that dispute. In that prior example, you've got an ongoing relationship with somebody, one of your multiple projects, you want to clear that dispute from one of the projects you're working on, or maybe just a portion of that project. So the idea is a release is going to allow everybody to legally put it behind them and move forward with a clean slate. The other reason, and more specifically here to construction, is you might want to execute a release because you're being asked to release your mechanics lien rights, or you need somebody else to. Even if you find yourself as a subcontractor, who is typically the one being asked by a general contractor to release your mechanics lien rights, you may also find as a subcontractor that you've gone and purchased materials, or you've had another sub working for you as well, and you may be asking those people to release their mechanics lien rights. So I would say that note, you want to release mechanics lien rights only when you've been paid for them. So when you've satisfied the lien rights, you want to acknowledge that they are resolved. Most owners or general contractors are going to want to see that, which is why they're going to want to release when they pay. I would also be remiss if I didn't say that, practically speaking, a lot of people are asked to release mechanics lien rights because the owner simply wants to clear the title and doesn't want to see them on the project. That's an issue that I think needs to be looked at a lot further. If you have not received payment and you are considering releasing your mechanics lien rights, you are giving up a significant amount of leverage. And that is because in Massachusetts, the mechanics lien process starts with recording a notice of contract. That notice of contract can be put onto the title of the property by going to the Registry of Deeds and doing a filing of one page. And that can be done as soon as you execute your contract for the work. That preserves the maximum value of your lien, because presumably that early on in the project, people have not been paid out. So it preserves the highest potential value of your lien. You are getting it on record. Everybody knows you're out there. That is what it's designed for. There are a lot of owners, however, who don't like to see mechanics liens on there. A lot of financing banks who are concerned with that. So they will ask you to release your mechanics lien rights. If you execute that release, then you are going to have no mechanics lien at that point. You can refile it as you incur expenses and as the bill comes up and is unpaid. You can refile it within the mechanics lien window, but you have lost that earlier priority and potentially the unfettered amount of your lien. As the project goes, the owner pays the GC pays the subs. As a subcontractor, your lien is worth less money because the owner doesn't have to pay twice. So there's a lot of issues here about releasing a mechanics lien. I would suggest that you not execute a mechanics lien unless you have actually received payment. If you're being asked to release a mechanics lien, whether it's just at the notice of contract stage or it's gone further, and you have not been paid, but you're asked to do it, I do understand that practically speaking, you've got issues with wanting to keep your general contractor and the owner happy, but that's a significant amount of leverage you're giving up. So I would definitely talk to counsel, make sure that and that you really understand and evaluate the risks of releasing a mechanics lien that is one that you put on the project early. All right. So if you get presented with a release, check this checklist. So here you go. RTFC, this is one of my favorite acronyms. It means read the blank contract and ask questions. So many people get these, they think that they all look alike. They may reference the statute for the mechanics liens. There is a discharge section of the mechanics lien statute that has release language that they could use. But again, all of these are individual, and they're a document that's being presented that has real impact on your company's mechanics lien rights. Please read the contract, ask questions. If you are not an attorney who's well-versed in construction law and hasn't have 20 years under your belt like I do, you should not be expected to read and understand everything. So ask questions when you have them. That's very important. Don't ever sign a contract, mechanics lien release or any other contract, unless you really understand what you're signing. And certainly don't think twice about what it makes you look like to have questions. To me, it makes people look smart when they're willing to express that they don't know what it means and that they want to find out before they sign something. So here's the other checklist. Make sure that the parties are properly named and that they are named in full. Use your Secretary of State's website to check and see the corporate or LLC names. Make sure that you've properly included it and that you can understand who's reading and who's signing them. Make sure that the name is typed. Make sure that you understand their position and that they have the proper authority to execute a release. Make sure that there is consideration stated in the release. Even in a release of a mechanics lien or a release in any other situation, it usually starts to say, for consideration in the amount of X dollars. It's going to tell you what's being paid. That is the consideration to the company signing the release, that they are giving up their rights for that amount of money. Make sure it is stated as to what that consideration is. Also, because without stating the consideration, that release could be void in the future for lack of consideration. But also, when is it to be exchanged? Know the scope of rights of what you are giving up. This is one of the most important things when you're looking at a mechanics lien release. I cannot tell you the amount of times I have people send me over a mechanics lien release. It is not a mechanics lien release. It is a release of all rights as to sue on the project. And people will sign those without a second thought. So please, again, go back to that first one. Read the contract, read the document, ask questions, really truly understand the scope of rights you are giving up. A lot of owners and GCs will include an entire general release of claims as to the project without telling you, and call it a mechanics lien release. There are partial releases which you should be executing along the way for in exchange for payments with mechanics liens. Those are very common. And then what you might see is a final waiver or release of mechanics liens at the end of the project. Even then, at the end of the project, I would not recommend signing a full waiver and release of all rights. It's fine to release mechanics lien rights when you've been paid. So you're going to release, if you're paid on a monthly basis, for example, you're going to release your mechanics lien rights as to February. When you get the check for February, you're going to have a specific date in there. It's going to say for all materials and labor provided as to February 29th, 2024. That is a limited release. It is a partial mechanics lien waiver or release as to all your rights for the month of February. And that's because you've been paid for it. It's entirely appropriate. When you finish a job, it's entirely appropriate to waive your mechanics liens as to the entire project. But in both circumstances, it is not necessary for you to release all of your claims for breach of contract, breach of warranty, for negligence. You may find something comes up that something has happened and you find that out later. You don't want to release any additional rights that you have. Keep it limited to your mechanics lien. Also on this checklist, you want to check, what does the release say for the state's law and the jurisdiction for any dispute under the release? Especially important if you have companies who are, maybe you're dealing with a company from Rhode Island. So the question is going to be, are you going to have to pursue or defend a claim under the release in Rhode Island. If you're a Massachusetts company, you want to be here. So make sure that your release states what the jurisdiction and choice of law is going to be for any disputes, and then check to make sure it is properly executed. Check to make sure if it requires a notary, that the notary has been done and it's been fully and properly completed. What to avoid? This is basically the antithesis of everything I said. Ambiguous language, terms you don't understand, giving up more rights than necessary. You know, these are really important, and these are things that when you read the contract, read the release, if you don't understand it, ask those questions. Avoid unnecessary formalities. Again, going back to that first slide of what is a release is anything that releases your rights. It can be 3 sentences in an email for a release as to general rights. For a mechanics lien, it is going to need to be in writing. It is going to need to be notarized because those are recorded documents. But avoid unnecessary formalities. It doesn't have to have a legalese or some structure to it like that. If you're writing your own release, make sure it's understandable to the parties, especially if it's broadly based. If it's a mechanics lien release, cite the mechanics lien book and page that's been recorded, identify the parties, and say that it's been waived or released. No unnecessary formalities. It just clogs things up. And then people who go ahead and use these again might get caught up in some of that formal language they think they have to keep. And certainly make sure you're looking at it so that you don't have incomplete or illegible signatures. If you find yourself 2 years later having to file suit and you're not sure who executed the document, you're the one who needs to rely on enforcing it. What are you going to do? So having the name of the person who executed it typed under there, making sure it has their position, or showing that they are duly authorized to execute it. Exchanging the release for payment. There's a right and a wrong way. Contemporaneous is the absolute best way. I'm going to hand you the document and you are going to hand me the check. If not, you may consider using an escrow agent if the funds are large enough, which is I will send that to my attorney. When I get the funds, my attorney will release it to you. Or if you're going to be doing it electronically, which is very common, people get wired funds, people email around a release. Know that in Massachusetts, a notarized document that is emailed can then be recorded with the Registry of Deeds. Just because they don't have the original doesn't mean someone is prevented from doing that. So be careful with what you send around. If you just watermark it draft or not yet effective, if you email it around, there are Acrobat programs where people can take those things, the watermarks off. So I would prefer, if you're exchanging a document, you would either exchange it contemporaneously in hand, expressly state when it's effective, this is not effective until we receive payment, or use an escrow agent. So those are the best ways to do that to make sure you're protecting yourself. I've wrapped up in 18 minutes. Hopefully this gives us a chance if anyone had any questions, or if not, just to allow Jesse to close us out.
Well, first of all, Jessica, thank you so much. You did really great. These are really good points to kind of keep in mind when we're signing waivers and releases and making sure that we are covering ourselves and protecting ourselves. All right, so I do have a question that came through. And I think you kind of touched on this already, but we'll go ahead and ask it again. Is there a standard form that must be used for a release?
Yeah, and there is not. So whether you're talking just generally, for any project, releasing any rights, you can use any language that you'd like. For a mechanics lien, there is a statutory form. One thing I did forget to mention, so thank you for asking the question. One thing to keep in mind about mechanics lien releases, again, they do not have to have specific language. There is a statutory form that you can use if you'd like. That technically applies only for the general contractor. But in Massachusetts, you cannot be required to give up your mechanics lien rights in advance. That is against public policy, and even if you were to execute it, it is not enforceable. So that means if you're working on a year-long project in 2024 and you've done work, you've been asked to sign partial releases up through the end of February, for example, because you've been getting monthly payments, that's fine. If the GC comes to you today in March and says, okay, I'm going to have you sign a waiver or a release as to your mechanics lien claims for the rest of the project, that document is not legally enforceable. I recommend, because it's not legally enforceable, that you don't sign it. Because if you sign it, there may be people who think it's enforceable, especially on your side, who get concerned about what they can do. I would recommend not signing it. It's not enforceable. Why would you sign a document that you know has no legal force and effect? There are circumstances where you may want to keep the owner and the GC happy. You may sign something that you know cannot be enforced against you because you're feeling pressure or threatened to do so. But again, I would rather see you not executing a document like that. But just to circle back around and answer that question definitively, no, there is no specific form that you are required to use.
Okay, well, thank you. And I think this one kind of goes along with that same train of thought. And I'll kind of give you my take after I read the question. Is there one certain phrase or legal language that you recommend that's included on your waiver or release that protects you in a conditional versus an unconditional waiver? And I think they're stating if it's, you touched on it a little bit, if it's a partial release and that's sort of a situation.
Yeah, and so I think in those circumstances, you just want to make sure it's clear and understandable. That is unambiguous. So even if you have to, typically what I'm going to put in for language is releasing all claims, rights, and interests in the project, pursuant to this contract on this date. That's going to release all claims. If it's going to be limited, then you're going to say, regarding this invoice. You can also, when you get done with that language, include something that says, to avoid any ambiguity or uncertainty, this means party X is releasing only some of their rights. And you can be as explicit as you want to be because the key here is somebody else is going to evaluate this in the future, and you want that person to be able to understand exactly what's going on. One trick that you may see is the including but not limited to language. So if you see something that says X company releases all rights, interest, and claims as to project Y, including but not limited to, it's going to give you examples of what's included, but to know that everything is included with respect to the project, because it's including those things, but it's not limited, it's everything about the project. If you want to make it more specific, what you need to use is not the included but limited to language, but you're going to want to talk about releasing claims related only to, or related specifically to, or just related to invoice 10, related to the work done in February of 2024. So you are in charge of that language, and it's just something you want to, I would run it by somebody who's not familiar with it. Hey, what does this mean to you when you read it? If you're going to come up with your own language, but you can come up with your own language, and that's kind of how some of the distinctions work. I hope that was helpful. I know it's a tough situation, and I'd be happy to, if anyone had a specific, line or question about how to include something, you do have my email here. More than happy to take a quick question or phone call on that and give you some specific advice.
Perfect. I think you answered that really well. Those are really important distinctions to make, just to make sure that you're covering yourself and not sending over a release for a full project that completely gets them out of the clear and releases your lien rights if you still have a stake in the game that you're waiting on. All right. So if anyone does think of a question that wasn't addressed, please feel free to reach out. We will be sure to answer any further questions. Like Jessica said, you can send her an email. You can also send me an email, and I can try to look into it for you further to get you over that information. Can you go to the next slide for me, please?
Sure.
All right, so here we have a pop quiz. We're going to test you guys. pay attention. If you guys think you can answer these questions correctly in the chat, go ahead. We'll send you guys over a little gift from SunRay. Here are some of the questions. A release must be entitled release or use the term release within it. True. It's the only way to know it's a real release, or false. And then the next question, mechanics lien releases are standard and can be executed without scrutiny. True, everyone uses the standard form, or false. We've kind of touched on these, so drop your answers in our chat and we'll get you over a little prize to you guys. Go ahead and scroll to the next slide, please. Thank you. All right, so here's some of the SunRay resources to help you guys stay organized, know your deadlines, secure your lien rights. We've got deadline calculators, project information sheets. We've got your state lien laws, lien calculators. There's so much on here. So go ahead and scan that QR code to access these incredible resources. Can you go to the next one for me, please? All right, so we have a new service at SunRay. SR Receivables will be handling your collections for you. We're here to help get you guys paid, so check it out. Give us a call or send us an email, and we would be happy to give you some more information on that. Next slide, please. Okay, pardon me. All right, here, if you guys don't mind, take a minute to review us on Google. We really appreciate the feedback and take it to heart. It also helps get this information out to other contractors like yourselves. All right, go ahead and go to the next slide for me, please. And with that, that is all we have for you guys today. Thanks so much for everybody that attended. We hope to see you guys at our next webinar. Thank you again, Jessica. You really are incredible. And I hope you all have a wonderful sunny day. Thanks again, everyone.